Hi, welcome to the third session in our webinar series on reform of the ABA Model Procurement Code, of the MPC. Full information on this webinar is available at publicprocurementinternational.com. My name is Chris Hukins. I'm a professor at the Government Procurement Law program at George Washington University Law School. The opening session last week gave us an introduction to the MPC, and we will discuss potential areas of reform of the code, which hasn't been updated since 2000. In the second session of our series, Scott Scheffler, who's joined us here this evening, of the Felsman Tucker firm in Washington, D.C., discussed Office of Management and Budget, or OMB, grants guidance in detail as it relates to procurement. That guidance directs federal grantees on how they should conduct procurement using federal grants funds. Historically, a core role of the Model Procurement Code has been a model for federal grantees. If they followed the MPC when they procured, they could be confident that they've complied with the federal government's guidance for grantees. We'll be talking about that more this evening. However, it's no longer true that the MPC is in conformance with the grants guidance from the Office of Management and Budget, because the MPC hasn't been updated since 2000. The reform of the MPC will therefore likely focus first on bringing the MPC up to date with the OMB grants guidance. Scott described the grants guidance in detail on Thursday, and his session is on the program page at publicprocurementinternational.com and on the GW Law Government Procurement Law program YouTube page. We're also joined, by the way, this evening by Keith McCook from South Carolina. He's long been a supporter of the effort to reform the MPC. We're very, very grateful he could join us this evening. This evening, we'll be discussing the next step in the analysis. Will they be discussing a gap analysis, or what needs to be done in the Model Procurement Code to conform it to the grants guidance? I'll be joined in the second hour by Yolanda Williams, whose paper at GW Law School formed the foundation for this evening's presentation. She wrote about this gap analysis, and we'll be publishing her paper from GW on the program page in the coming days. On Thursday, in a couple of days from now, at the same time, we'll be joined by GW students Brandon Hancock and Jacob Berkowitz, who will discuss cybersecurity, and we'll also be discussing StateRAMP, which is an important cloud-based solution for dealing with cybersecurity issues at the state and local level. We'll go for about an hour this evening, then we'll take a break, and then we'll finish up by 8 p.m. Eastern. So if you have any questions this evening, please feel free to submit your questions in the Q&A, and Keith or Scott or I or Yolanda in the second hour will hopefully can respond to your questions. We welcome questions from our participants. If you're interested in our program at GW, if you go to the Beyond the FAR page, full information on our program. As I said, this evening we'll be comparing OMB to the OMB grants guidance to the MPC and talking about that gap analysis. And then on Thursday, in our final session, we'll be discussing cybersecurity issues. As I said, this gap analysis is based in an important part on an analysis done by Yolanda. She just graduated with an LLM from the law school. We talked about in the first session, the Model Procurement Code was drafted in the 1970s, and then it was updated in 2000. There also are proposed regulations from 2002, and then there's a public infrastructure procurement version of the Model Procurement Code from 2007. We'll be referring this evening primarily to the 2000 version of the code and to, in some cases, to the regulations from 2002. So this is in a quote from an important article done by Trovell Bauer, who was a prominent lawyer, in fact, general counsel for the Navy during the Eisenhower administration. And he was very much one of the fathers of the original MPC in the 1970s. And he wrote an article, A Personal History of the Model Procurement Code, was published in the Public Contract Law Journal in 1996. And he talked about some of the very important things that fed into the Model Procurement Code, key people who participated, and also he talked about the organizational structure within the public contract law section for dealing with it. He said he pointed out that in the 1970s, state and localities receiving federal grants abruptly were required to comply with complex and rigorous federal procurement standards. It was these standards, as we discussed in an earlier session, that during the Reagan administration receded because of concerns about federalism, but during the 1970s, the state and local grantees were suddenly met with very serious requirements that they had to meet in order to do procurement using federal grants monies. However, he pointed out there was a bright side for those of us working on the MPC. In the late 1970s, the federal authorities decreed that a state or locality that adopted the MPC would be deemed to have complied with federal procurement standards. So As of that point in the late 1970s, the MPC and the federal grants guidance were in sync, and a state or local grantee that adopted the Model Procurement Code would be in conformance with the OMB grants guidance. So we said, hence, adoption of the MPC became an easy way for states and localities to comply with these new federal standards. So that's really what we're talking about this evening, returning to that point where the MPC and the grants guidance are in sync so that grantees can rely on them readily. So Scott last week in session 2 on Thursday talked about some of the key elements of the grants guidance, the most recent OMB grants guidance, and we talked about them in some detail. You're welcome to go look at that session 2. We'll be returning to each of these elements now. We'll be turning to the ones that Yolanda Williams highlighted in her paper as some of the most important provisions that the MPC has to be updated to meet. There are some significant deviations between the OMB grants guidance and the Model Procurement Code as it stands right now. We'll be focusing on those. Some of these are largely in sync with federal practice, and some of these are ones that we won't have a chance to get to this evening, but just want to highlight for you here as sort of open issues, because they're very open issues. Well, one thing we won't have a chance to talk about this evening much is micro purchases. And micro purchases are morphing very rapidly at the federal level and in some states, partly because of the existence of online platforms like Amazon.com. The federal government has opened the door to Amazon, to Fisher Scientific, to Overstock.com. GSA allows those companies to sell directly to federal purchasers using the credit cards, so the government purchase cards. And that, in effect, has taken the procurement personnel out of the loop. So as we discussed in an earlier session, that's a major issue to be thought through in the MPC reform process. Does the MPC actually have to address how Amazon or other online platforms are used within the procurement process? Should be tighter integration. There have been some significant issues, as we discussed in the earlier session, on how to deal with Amazon and other online platforms, because the online platforms, and I wrote about this with a few other authors for the briefing papers and that are published on Westlaw. Amazon, you can see from the negotiating history between Amazon and the other platforms and the General Services Administration, Amazon has tremendous negotiating leverage in those discussions, and Amazon resisted changing its business practices for the GSA agreement. So as a result, in essence, the micro purchasers, the folks who are buying up to $10,000 from the government, who are buying through Amazon, are in essence buying which you would normally see in Amazon Business. And they, as a result, federal requirements like the Huawei requirement, the no Huawei requirement, or other federal requirements may not be fully met in that process. So there's a friction there between using these online platforms for micro purchases. And that's something that needs to be discussed, and that has to be discussed in the MPC reform. The other is the contract clauses, and the 2007 version of the MPC that was developed for use in the public infrastructure space has contract clauses. The question is whether or not those contract clauses would have to be adopted more broadly to be used in the normal course under the MPC. We did a gap analysis early on in the MPC review process to try to identify where there's a split between the grants guidance and the MPC. And that formed an important foundation for what Dixon Robertson and the other reporters are doing in terms of framing up the work that needs to be done on the MPC. And you see some of the points here. We're not going to be able to discuss all of them this evening. We did discuss them in earlier sessions. And one of the things that, because they're so complex, that we won't be able to discuss fully is the question of the Buy American requirements, the domestic content requirements. As Scott pointed out in the earlier session, it's actually a bar against regional or state, let's say a Buy Alabama requirement. Those things are banned on existing grants guidance, but there is a broader admonition to Buy American, if at all possible, using federal grants money. So how to square those requirements is an open question that we'll have to review in the MPC reforms. Interestingly, the Model Procurement Code anticipates there will be gaps between the Model Procurement Code and the grants guidance, and emphasizes that those receiving federal grants will have to comply with the federal grants guidance. So the MPC realizes there might be gaps. And if you look at the commentary, what's interesting about the commentary, it says that the state are the states that adopt the MPC. They're expected, or the local governments that adopt the MPC, they're expected to follow the federal grants rules. They say they recognize the gap, and they say the drafters of the MPC contemplate that most of the requirements falling within this provision, this gap, will be socioeconomic in nature. So what the drafters were anticipating is that there'll be gaps, especially with regards to socioeconomic requirements, preferences, let's say, for women, whether or not those socioeconomic requirements may be out of sync with the MPC, and then at the end of the day, the state or local government that's adopted the MPC has to follow those socioeconomic requirements, even if they're not fully set forth in the MPC. This is drafted, of course, for the 2000 version, for an earlier version of the MPC. Given the substantial litigation that's likely to come with regards to various types of preferences in the wake of the Supreme Court's recent decision on affirmative action and the question of strict scrutiny, both with regards to race-based preferences and with regards to gender-based preferences, we're likely to see a lot of variation in this area. And so this still holds true. One of the areas where there's going to probably be a gap at the end of the day between the grants guidance and the MPC is in this area of socioeconomic requirements. Okay, so a starting point for understanding all this is that the states are, as we discussed the other day, the states are allowed generally to follow their own procurement procedures, except for certain special requirements regarding contracting with small and minority businesses, women-owned businesses, domestic preferences for procurement of recovered materials. Scott, if I could just bug you for a second on this requirement. When it says states, how low does that go in the chain? Does that cover all state agencies? Are all state agencies, when they're receiving federal grants, covered by this exception so they really can follow their own procurement rules?
That's correct. So it's actual state agencies. I would say there are a couple of areas where you may think, well, is this particular entity a state agency or something else? The best example would be institutions of higher education. So a state university system, they'd be considered an institution of higher education as opposed to a state. So they would fall in the bucket of comply with all federal procurement standards. Another area that you see from time to time is entities like special districts, for example, hospital systems, et cetera, that are creatures of the state, but operate more commonly, in my experience, as local government entities. And local governments, in fact, when you think in terms of gap analysis, local government entities oftentimes are subject to the state procurement code, but they're actually not state entities. Even if they're created under state statutes, they're local government entities for purposes of grant funds. So really, we're talking state agencies that don't fall into either of those buckets, which is most state agencies.
So how do we know where the line is? Is there something that explains in the uniform guidance where the line is, let's say, between the state and the institution of higher learning?
I don't recall off the top of my head. There is for purposes of indirect rates. Whether or not there is specific to procurement, I think there's not specific to procurement. I could take a look at whether there's a more general statement. I don't believe there is. Custom and practice is that institutions of higher education are exactly that, institutions of higher education, not state agencies.
So for I'm sorry, Keith, go ahead. You're on mute, Keith.
I was going to point out that this particular section provides an opportunity to illustrate some of the types of issues that are going to bubble up when we re-examine these provisions in light of the OMB guidance. While a lot may not have changed on this particular point, maybe it has, but even if it hasn't, we're going to have the opportunity as states to look at the lessons learned, particularly if we get broad participation, to see what problems have bubbled up. So a problem that bubbled up in South Carolina is that most states have some type of bid protest process. Well, in South Carolina, we've had a number of bid protests bubbled up regarding the application of a federal requirement that was inconsistent or was going to result in an award to someone when the process was going to be different if we had just followed state law, which called on state procurement officials to decide issues of federal law. What does the federal regulation require? And are we applying it? And we've had several instances where we've reached out to the federal agency that's administering the grant, and they will not give us a definitive answer or anything in writing. And Scott's smiling because he's familiar with this challenge. So the procurement officials in the state are left with deciding these issues, and then there's appeals, and we're really not set out for it. So in South Carolina, we exempted the CPO's protest jurisdiction to exclude anything that involved directly interpreting the federal grant rules that we have to follow pursuant to the model code provision that says follow the federal grant rules to the extent they're inconsistent with state law. And I think that as we go through this process, we're going to find other instances where experience has taught us lessons that perhaps need to be thought through as we think about amendments.
Well, let me press forward on that point a little bit, because I think it's important, Keith. One of the, my experience has been that in working on a model law like this, identifying areas where we don't need to disagree, where we don't need to have arguments, is really important, because it holds the process together, and it reduces time, and it certainly reduces friction. With regards to the first one, contracting with small minority businesses, women in business enterprises, and labor surplus area firms, since this covers both states and the non-federal entities, it's obviously an important part of the guidance. But I'm wondering whether or not we just want to leave this rest on the language from section 11301 and say, so just walking through a hypothetical, whatever the Biden administration has with regards to these minority and women-owned business preferences, whatever the Biden administration has, if another Republican administration follows, there's likely to be a pivot. There's going to be a change in direction. So if we in the Model Procurement Code try to anticipate what socioeconomic requirements should be put in, we're putting ourselves into a sort of a loser's box. So I wonder, with regards to this, it makes more sense to say, you know what? This was an approach that was taken in 2000, where we carve out these issues and say, you have to follow the federal grants guidance, but we're not going to tell you how to do it through the Model Procurement Code.
Agreed.
Scott?
I think there's another reason with respect to socioeconomic issues that you may want to carve them out, and that is they vary greatly program to program. So a really good example of this is Davis-Bacon. I wouldn't be surprised if the drafters of the prior version of the Model Procurement Code that were thinking in terms of that commentary were even thinking about Davis-Bacon, because sometimes it applies and sometimes it doesn't. And even under the uniform guidance, what it says is, well, Davis-Bacon applies when the statutory authority for the particular grant program says Davis-Bacon applies. And so even across grant programs, it's not consistent. So it would be very difficult, I think, to have a standard list on the Model Procurement Code side, because there's really no standard list on the grant side. There's some stuff, but it's not significantly impactful to try to incorporate it, in my view, into the MPC. The stuff that really matters is still ad hoc on the grant side.
So there's a question here saying higher education institutions receiving federal grant money, even if through a state, must comply with all federal procurement requirements, not just the 2 CFR 318, 327 requirements. Sorry, that site is hard to input on this phone.
So that's what I said, and that's my interpretation of the uniform guidance. If you're a state university or you work for a state university and you've taken the opposite position, I think a case can be made. Look, you're a state agency. In my experience, institutions of higher education see themselves first and foremost as institutions of higher education and not state agencies. But it's certainly something that could be debated. To Professor Eukins, to your point, I was looking back at the definitions section to see if there's something I've overlooked. There's not a clear distinction made. So I think you can make the argument they're state agencies. Again, in my experience, they don't look at themselves that way.
When we talked about earlier in the last few minutes, we talked about a carve out for socioeconomic. We talked about preferences for women and race-based preferences. Those are likely to be a fluid area over the next few years. So we want to carve them out. I want to just return to Scott's point about variations within programs. And Keith, this is for purposes inside the MPC committees, so to speak. That another area of fluidity and of difference from program to program is on the domestic preferences. So we discussed in the earlier session 2, Scott discussed the fact that even things like the Build America, Buy America requirements, those domestic preferences, they can vary dramatically from one agency to another. Like the HHS, for example, is taking the position that it doesn't do infrastructure. And Scott and I happen to disagree with that based on the broad definition of infrastructure on the Build America, Buy America Act. But under this domestic preferences provision, there's fluidity from agency to agency. So again, I think that this entire area is a good area for carve out based on the position that was taken in the 2000 law. This carve out here. Okay, I want to talk a little bit about independent price estimate. And Keith, I know you've talked about this before, and Scott's talked about it. It's an interesting problem because it's really changed now. That the OMB guidance says the non-federal entity must perform a cost or price analysis in connection with every procurement action in excess of the simplified acquisition threshold. As a starting point, it says the non-federal entity must make an independent estimate before receiving bids or proposals. In your state practice, Keith, is it normal for the agencies in South Carolina to prepare independent price estimates?
No, not that we see. There is some internal process that agencies undergo to get some sense of whether or not what they're trying to do can fit within the budget. And I'm focusing primarily on non-construction. There's so much information available for commercial items, and we don't have that definition in the model code, and we don't have it in South Carolina. It's not a topic you ever hear about at the state and local level, but the concept's very familiar at the federal level, and so much of what we buy is commercial items. So we do have some idea of the pricing, right? If we're buying equipment or commodities or software, there's a lot of information available. Construction, we have a much better idea, and institutions ordinarily do some type of internal estimates before they go out for construction. But for so much of the rest of it, large complex contracts like outsourcing food service for a university or large IT projects, there's very little of that done in any formal method. So how they deal with this and how they respond when the federal government comes in to ask questions is something I haven't run across, but we don't see that kind of cost estimating going on, at least not in the central procurement shops.
In the federal space, the agencies have if they do an independent price estimate, they are allowed to, it's their choice whether or not they want to share it with the contractors. If you share it with the contractors, you're creating you're almost facilitating price cooperation because you're giving the contractors a target. If you don't share it with the contractors, as a practical matter, during a bid protest, it may be the subject of either a price reasonableness attack or a price realism attack if there's a huge variance between the winning bid and the independent price estimate. Scott, in your experience, are your grants clients, are they prepared to deal with the requirement for independent price estimate?
Short answer, no. I don't think most grantees are doing a very good job of actually preparing independent price estimates in advance. And I have never seen it arise as a compliance finding. So when procurement is reviewed by agency officials, or if it comes up as an issue in an audit, it tends to be that where you'll actually have a compliance finding is when you simply didn't follow the required competitive procedure, meaning it's over $250,000 and you didn't use an RFP, or it's over $10,000 and you simply only got one quote. These specific details of you should have had an independent price estimate aren't turning into compliance findings, at least not presently. But no, generally speaking, I would say compliance in this area doesn't seem to be great.
So this is a good example, and it's something I wanted to walk through with both of you. Is that so? Your one's first inclination is well. Let's step back on this. Their experience after Hurricane Katrina was that FEMA was fundamentally unprepared, and many federal agencies were fundamentally unprepared for dealing with Hurricane Katrina from a procurement standpoint as well. And one of the proposals that was put forward right after Hurricane Katrina was, hey, let's create a part of the FAR where we collect a checklist of emergency procurement authorities. And I for one thought it was a goofy idea. I thought, well, okay, but it's there already. Why are we just creating sort of a checklist or a phone book of a menu of emergency authorities? But it turned out to be really important during, for instance, during the pandemic. That portion of the FAR that lists those emergency authorities turned out to be really useful. And so logically, Keith, one of the things to do here would be to create a checklist of things that under the OMB guidance, MPC adopters should be doing. Among other things, they should be creating an independent price estimate. But at the same time, we're hearing from Scott that it's a practical matter they don't often, and it's not really commonly a focus of audits. What do you think we should do? Do you think we should put brackets in, or should we not just try not to create a checklist to make things easier? What do you think?
I just did a quick search. One of the topics that has gotten a lot of conversation between me and one of the lawyers in my shop in the last year or so, maybe two, has been the lack of focus on price reasonableness and the lack of any mandate to compete the price for all the work that we're getting. And really, competition doesn't get as sharp as it can get until you require a price on every bit of the work the contractor is going to perform. I just did a quick search in the Model Procurement Code and the Model Regs, and I could not find any occurrence of the phrase price reasonable or price reasonableness. Now, maybe my quick search missed a few because it's a PDF search, but in the South Carolina Code, which was based largely on the model from '81, there are references in the regulations, but there is no requirement anywhere in the law that the procurement officer that's clear, that's black and white. There's no ifs, ands, or buts. It's not inferred or implied from the structure of the code. Black and white, you have to determine price reasonableness. And so the entire point of doing an independent price estimate is to have some basis of determining whether your price is reasonable. The example I like to give when I teach people is our regulations allow you to require you to make an award unless you have a basis not to make an award that's compelling. And one of the regulations, one of the justifications in the regulation is that the price is not reasonable. So I give the example of someone puts out a bid for a tractor, tractor trailer 3 days before the Christmas holiday comes in. The vendor looks at it and says, nobody's going to be paying attention. I'm going to bid at 50% higher. The price comes in 7 days later, the minimum bid period in the state of South Carolina, and the price is indeed $500,000 higher. That's the only bid they get, but they conducted an IFB. It was publicly noticed, so legally they can award. The procurement officer is the one who's supposed to determine that price is completely unreasonable. We're not going to pay it. I've met many procurement officers who feel like they have to make that award because they aren't used to this very fundamental concept, which I hope to see bubble up in the MPC revision process, of saying, no, you have to look at price reasonableness. And while I don't anticipate we're going to see the type of independent cost estimates that the federal government does, I do believe, given how much we do with commercial items, that we have an opportunity to provide a push and a framework for a more robust look at this. We in South Carolina did it in 2019, or maybe it was 2020 when we adopted the implementing regulations, to adopt just a very minor but meaningful framework to kind of push in this direction. So I don't think we're going to go where the federal government has gone. And quite frankly, I don't fully understand the independent cost estimate framework at the federal level, but we need to do more than I think is currently in the model code.
So you've thrown a lot of stuff out there, Keith, and I want to ask a couple of questions about it. So, and it really starts, because we're going to talk in a couple of minutes about the concept of risk analysis and risk mitigation, that a lot of good procurement, good public procurement is becoming an issue of risk mitigation as opposed to administrative rules. So that takes us to the why question, and also tells us about how we handle the why question. Why do you think that price reasonableness is an important consideration at the federal level? The way, and this has come up recently there was a very important interview given by Shay Assad, who had decades of experience in constant pricing in the federal government, in the DoD, and he gave an interview in 60 minutes. It was seen by like 25 million people, and he said that he thinks that the Defense Department is paying too much for certain things, let's say spare parts, for example. And the criticism was, well, look, if you pay too much, if the price is too high, the risk that the government as the agency is taking on is it can't buy as many weapons as it should. So the risk is really, if you look at it from a supply chain perspective, the real risk is we're buying less of an essential product. Is that when you train on this and you talk about it in South Carolina, is that what you're focusing on when you're saying the price is too high?
We've tried to push us in the direction of doing more risk analysis. And you make an excellent point, but that's not the policy justification. I can think of two off the cuff, one of which is we're stewards of the taxpayer money. We're expected to get best value for the dollar. And that's a big deal in South Carolina. I'll give you the other one would be if a contractor is charging you so much above their cost, and if you just look at the unbalanced bidding framework, one way to look at unbalanced bidding is if the contractor is overcharging you or is charging you so much above their profit level that they're going to earn their profit long before they finish performance, you've undermined the likelihood that they finish performing or that you have leverage over them. So the very idea of overpaying substantially has a contract performance risk separate from just not getting good value for the taxpayer.
That's very interesting. Now, normally, when I teach on corruption, I explain to students there are three risks that are actually at play with corruption. There's the performance risk, there's a reputational risk, and then there's a fiduciary risk, which is the money is not being spent the way it should. If you're supposed to buy a house, the government's supposed to buy a house, and instead of buys a boat, that's a fiduciary breach. It has a fiduciary obligation to taxpayers to spend the money appropriately. I say normally we don't really think about that much because it doesn't come up that much when we're dealing with corruption issues. In essence, you're seeing a system failure, a fiduciary failure, if the state doesn't spend money the way taxpayers would expect. Very interesting. Okay.
I'll give you a very quick example that was very compelling. We had a major, very high profile contract. The General Assembly had specified X amount of dollars, which created a problem you referred to earlier. Since everybody knew the price, we expected everybody to fall in about that price range. I went to my agency director, who headed the central administrative agency for the state at the time, and suggested that we say, we're going to spend X amount of money. We want the most we can get, the best performance we can get for that dollar, and just bid it on performance and quality and how much we were going to get. She loved the idea. She took it to our Senate Finance Chair, who rejected it immediately.
Really?
There
Why?
must be competition on price.
Okay.
And that reflects, I think, the feeling of a lot of legislators. We want price competition. We're looking to save our money.
So let me take this idea, your fiduciary idea, a step further, Keith, and just work it through. And I appreciate walking through this because in many ways we're laying a record here for how the discussion on these provisions can proceed. So in the world of suspension and debarment, if you're primarily dealing with a contractor takes a bribe, gives a bribe, and then builds a bad bridge and the bridge collapses, you say, well, we should debar that contractor. You're dealing there with performance risks, which is the bribing contractor almost invariably makes a bad bridge, and you're dealing with reputational risks. The government has taken a bribe, and therefore its reputation is undermined. And in those two realms, the reputational risk and the performance risk, the government is in the best position, the agency is in the best position to decide whether or not it wants to take on that performance risk or that reputational risk. I argue that's why with regards to responsibility and with regards to debarment, we leave a lot of discretion with the agency because it's a risk analysis. The agency is making the risk analysis. If the reason we're pushing price reasonableness is a fiduciary obligation, arguably, Keith, the agency shouldn't be the one making that decision because the agency has a self-interest engaging its own fiduciary obligation. It should be a much stricter rule when we're talking about fiduciary obligation because we can't leave it to the agency to decide what the boundaries are of its fiduciary obligation. Does that make sense?
It does, but it's such a disconnect from the way in my state, it works. At the end of the day, and perhaps it's best illustrated by our recent adoption of a framework very close to and modeled after FAR Part 15, because many state RFPs, competitive seal proposals, are very different from the federal model for competitive negotiations and don't actually involve simultaneous negotiations. And the model code might allow for, but doesn't expressly address, and we until 2019 did not have anything that facilitated the trade-offs that the federal government allows. But the trade-off analysis that's allowed by FAR Part 15 expressly allows, if I understand it, the source selection executive, often a high official inside the agency, to make this decision. The difference in quality that the highest ranked offeror is going to give me is not worth the difference in price. That to me seems to be a fundamental choice, very similar to, is this price reasonable? Is the price I'm paying for that extra quality worth it or not? And I realize they're different concepts, but in our world, that decision has almost always rested with the agency. Even with the central purchasing office, we're doing the work for them.
Yeah, I think what's interesting is that you may be leaving intact this concept of price reasonableness, that gosh darn it, we should really look at price reasonableness. That contractor that receives a bid 5 times as much as what would be reasonably should not be making the award. So I think we can leave the price reasonableness concept intact, Keith, and still give slightly shorter shrift to this idea of an independent price estimate. Because I got to tell you, in the FAR Part 15 world, the independent price estimate is not what drives the final price analysis. It's helpful. It's kind of lurking out there in the background. But because of the best value award, if you have a very high quality proposal that seems to be very high price, a lot of the assumptions that go into the independent price estimate go out the window. Nobody would bind themselves by the independent prices, which may explain why Scott is not seeing in the audits, because everybody recognizes that it's nice, but it's not dispositive.
If I may, I wanted to add 2 brief things. One is just in the context of this conversation, I know that from the grant standpoint, this section of the regs pertains only to acquisitions over the simplified acquisition threshold, so $250,000. There is other language around documentation that grantees have to maintain that essentially requires you to have you're required to have in your file for any procurement over the micro purchase threshold documentation that demonstrates how you determined that the price, how you reached the contract price. So it's kind of like a price reasonableness determination. When I advise clients, we just treat it as a price reasonableness determination. So this isn't only over 250,000, it's all the way down to 10,000. There's another thing that we talked about briefly just a minute ago, and it's a little bit off track, but I think it's worth noting because it needs to be fixed. And that is in the federal funding context, there's actually a separate law, and it's actually just enacted year over year as an appropriations rider in all the major grant-making agencies' appropriations. It's called the Stevens Amendment, and it requires grantees to include in their publications, including their solicitation documents, a statement of the total dollar amount of funding for the project and what percentage of the funding is federal. Grantees hate this because if the grant equals the project, it's not a broader grant with lots of little, individual solicitations within it. They have to required by federal law to tell the contractors how much money they have, and it creates the problem that you discussed. That if the contractors know how much money you have, then it really impedes price competition.
Very interesting. Thank you, Scott. So what's interesting, I just want to include this to talk a little about the MPC. The MPC allows the contracting official, the grantee contracting official, to reach out and ask for factual information that would be used to build an independent price estimate, but there's no requirement in the 2000 version of the MPC to actually do that the independent price estimate. what's also interesting is that the commentary to the 2000 version looks backwards to 79 and says, we've taken a different approach that historically we required, in essence, states to do an analysis analogous to cost of pricing analysis under TINA, the Truth in Negotiations Act, the old Truth in Negotiations Act. And that type of certified cost of pricing data was abandoned in the 2000 version, was really in the wake of a lot of the commercial item revolution at the federal level. The cost of pricing requirements at the federal level in the 1990s loosened, and the 2000 version of the MPC reflects that. And now we're kind of turning a corner back, where we're saying, okay, based on the guidance from OMB, we don't necessarily want cost of pricing data, certified cost of pricing data, because that's a very onerous requirements in contractors. But the OMB at least seems to be saying that they want an independent price estimate, although whether or not that would be rigorously enforced, as Scott pointed out, is an open question. And then here in the proposed regulations, under the 2002 proposed regulations, you see that the implementing regulations allow the contracting officials to get information, the price information that would substantiate get cost information, which would substantiate the price. But that's whether or not they would do that is an open question. And of course, that's later in the process too. That's a price reasonableness determination, as opposed to an independent price estimate. I think, as a practical matter, Keith, I think Scott would agree with me on this. Requiring an independent price estimate in every single procurement may be a mistake, may be overly tight. We want to talk a few minutes about full and open competition. And Keith and I love this because it opens up the whole question of how to deal with IDIQ, which will be one of the toughest questions we have to deal with under the Model Procurement Code, how to deal with IDIQ. So there's a requirement under the OMB guidance that you have full and open competition. And it says then in paragraph E that all pre-qualified lists of persons, firms, or products which are used in acquiring goods and services must be current and include enough qualified sources to ensure maximum open and free competition. Also, the non-federal entity must not preclude potential bidders from qualifying during the solicitation period. So Scott, you can either make our lives very, very difficult for the next few years. This is a couple sentences that are really important. Should we consider, do you think that the folks who wrote 2 CFR, Scott, thought these 2 sentences would apply to IDIQs, to indefinite delivery, indefinite quantity contracts, catalog contracts? Let's say like there's a catalog contract for Dell and a catalog contract for Apple. And then a very common, and these, for example, NASPO sponsors these type of catalog contracts, these IDIQs, indefinite delivery, indefinite quantity, and then individual governments or other grantees may make orders off these standing catalog contracts. Do you think that these rules, Scott, should apply to those catalog orders as well?
So my read of this, and also my policy view on this, is no. The way I read this requirement is that it's a limitation on pre-qualified lists of vendors before entering into a contract. So once you have the IDIQ contract, the process of soliciting offers for the IDIQ contract and then the fact of entering into the IDIQ contract gets you your underlying competition. I actually see IDIQ contracts in the context of the federal procurement standards for grantees. I see IDIQ contracts as the natural solution to we continue to sole source because of timing considerations, the same things over and over and over again. And we're starting to wonder whether our sole source justification really rings true at this point. I think when you're doing that, what you're really telling yourself is we need an IDIQ contract. Let's compete it every 3 or 4 or 5 years so we get price competition in setting the baseline prices in the first place, but that's my competition. So the pre-qualified lists applies at the initial competition stage, but not for purposes of issuing the task orders. There is an open question within the grant system that's I've never even seen commentary on this, which is if you have a multiple award IDIQ vehicle, whether you then have to compete the task orders. No one knows. I think the best legal argument is you don't, because you've got the underlying competition already, but I'd hate to see a situation where you have multiple contractors that hold those IDIQs and you don't compete it, the agency questions your cost, you have to defend, right, your situation. That's, again, is a little bit far afield, but in the grants context, that just becomes a problem because you have a very limited power in the relationship. And so it's going to take you years to fight out that disallowance. So it's better, you're better off just avoiding the problem. But the short answer, whether you have to compete task orders on a multiple award IDIQ is actually an unknown.
So and it's not an obscure question at all, because this is really it. If these provisions we're looking at, Scott, from the grants guidance don't drive the requirements for the task and delivery orders under the IDIQ. For example, you did a requirement for full and open competition doesn't mean you have to have a full and open competition regarding every single order that's being awarded. Okay, if that's the case, then the MPC drafting process, everybody's running, including some very important stakeholders, they get to the point where they have full and open competition for the IDIQ orders, not based on this, but because it's a good policy idea. You're reading this to mean that OMB is not telling them they have to have a full and fair competition at the second stage in the task or delivery order awards. That's not coming from OMB. That might be good policy, that might be good law, but OMB isn't requiring it.
Correct. That's my read of this. The way I apply this subsection E is that if you want to go through a process, and I understand a lot of state and local governments do this, a process of pre-qualifying vendors, especially for construction type work, that's fine, but it can't be a closed club. Either quarterly, you have to reopen the opportunity to get onto the list, or maybe it's an open list and you have a point of contact where potential vendors can submit their qualifications. And then you have a reasonable business process for reviewing those qualifications to periodically update your list. And if it takes you, let's say, 3 weeks to review qualifications, well, if you put out an RFP with proposals due in 6 weeks and someone says, well, I want to get on the list, then you run them through your 3-week process. And so I read it really purely as just pre-qualification.
It's very different. So if we applied it to the IDIQ world, so what you're saying, Scott, is there really 3 steps. There's a list, there's the actual IDIQ contract, and then there are the orders. And you're saying this only applies to the list. If it applied to the IDIQ contract, this is what the federal level is called on-ramping. You on-ramp people onto an extending IDIQ contract. And this has been very controversial area around the GSA schedules, because if an agency says, okay, I'm going to buy $1 billion worth of services off the GSA schedules, and someone says, hey, I'm not on the GSA schedules, by definition, under FAR Part 8, I should have an opportunity to compete. And any responsible vendor should have an opportunity to compete for this. Get me on the GSA schedules. And they say, no, you're not on the schedules yet. We have no legal requirement to get you on the schedules before the date that the proposals are due. That's been an issue, something we've been thought about for years.
You know, it seems to me what you're describing, and this is an area where I don't have a lot of knowledge, but it seems to me what you're describing is that the federal agencies, and in this case, the GSA approach, is to use multiple award IDIQs to such a significant degree that the initial award of the IDIQ isn't really a competitive award anymore. And I think maybe that's really the underlying problem.
That's an excellent way of posing it. And I want to get to your point. Well, just before I forget, because I'll forget, there are a serious discussion right now of having no price service IDIQs awarded, where you have no price whatsoever. So you're just saying, I'm going to provide legal services. I'm Felsman Tucker. I'm going to provide this range of legal services from partner, associate, paralegal, this range, and I'm not even going to quote prices to you. I'm going to compete when we have an order competition. That's when I'm going to put price on the table, and we can talk about price at that point.
Yeah, I actually think that's arguably not an IDIQ anymore. It's a pre-qualification, but yeah.
No, I agree. The pre-qualified lists historically have just been list of contractors, but I think what you're pointing out is no. As sage lawyers, we know that pre-qualification actually means something much more depth. In an IDIQ award, for instance, a no price IDIQ is really 200 pages of vetting in terms of qualification. Okay, so we have questions here. Would there be a difference between an IDIQ contract for a catalog of goods versus a catalog of services, such as an on-call contract based on time and materials where each task order is issued with a not to exceed value? That's a hard question. I think creating divides between goods and services, artificial divides, is very hard to sustain. Creating artificial, so for example, for a long time that we thought that software was a good because it came on a disk, and then it turns out no, it's a service because you can just stream it in from the internet. So trying to create a divide like that is tough. I think during the MPC process, and I welcome input from Keith and from Scott, as we're drafting the MPC, we have to think about what kinds of IDIQs, it may not be goods versus services, what kinds of IDIQs would we want more competition, both at the initial award stage and then at the order stage? What do you think about that? Go ahead, Keith.
Chris, I've been with the state of South Carolina Central Purchasing Office for 25 years, a number that's hard to swallow sometimes. And there has always been standing indefinite delivery arrangements for a wide variety of commodities, equipment, tangible items. And that process continued with software. The problems and the policy challenges from my particular perch have grown exponentially when we moved into services. And it's gotten most challenging with IT services. And I just recently went back and read your law review article from what maybe 2013, when the public contract law journal had an entire issue devoted to IDIQ contracting. And there were two articles, one that had Dan Gordon writing a section on GAO audits and yours. And both of them, when you read it, you come away with the very strong feeling that the real problems, the biggest challenges, the worst policy failures have been in IT goods and services. And I don't really think of software, the stuff that you used to buy on a floppy disk that you download now, but isn't provided as a live service, which is becoming increasingly rare, is the challenge. It's the ongoing services that I think, and particularly professional services, human performed services, that are the biggest risk. Is there a conversation to be had about other stuff like commercial items? Yes. But I think the biggest problem, and the one we ought to think about first, is not the coal and the asphalt emulsions and the office supplies and the laptops or the PCs. It's the more complicated services that have been such a problem through the audits over the years. I think the states are going through what the federal government did several decades ago, which is a massive outsourcing of services. And we're seeing a whole host of problems, whether it's PCI, OCI, or task order contracting.
So, and I absolutely agree with you, and I just want to put another layer on that, which is that when the really hard question about where do we require more competition, both at the master contract level and then at the task or delivery order level, those are really hard questions we're going to have to work out in the MPC process. Another wrinkle, Keith, is on your concern with regarding services, is that, well, if you have a pen, you actually have a fair amount of market discipline about the definition of what a pen is, and you have a lot of pricing that you can rely on to assess reasonableness. Is this the right thing to buy? Blah, blah, blah. There's just a lot of huge amount of market information you can flow in. Services, not so much. And so what happens, one of the things, for example, that you see, Keith, that has to come into the equation is that the centralized purchasing agency has an incentive, for example, to make things mushy so they can grab more of the market. Tough for them to do with regards to pens, because there's a lot of definition on what a pen is and what a reasonable price is for a pen. But if you're trying to say, how do we define services? Do we define services as, for example, lawyer of 1 hour, or do we say procurement lawyer of 1 hour, or do we say procurement lawyer with 40 years of experience, 1 hour? Okay, the mushier you make it, if you just say lawyer, then the agency can sell that contract. The centralized purchasing agency can sell that catalog contract to more customer agencies. They benefit from mushiness in the labor definition, but at the end of the day, the customer agency and the taxpayers don't, because if you're just buying lawyer, who knows, you're going to get some schmo, and that's a bad outcome. And so bringing into the calculation the question of the potential self-interest, potential distorting self-interest of the centralized purchasing agency is an important part of this equation. I'm sorry, Scott, did you have something?
A misfire, my apologies.
Yeah. So Chris, I have to respond because there are at least two people on the call as members of the audience that I happen to know that work with central purchasing agencies and are lawyers for them. I will tell you in good faith that while I have been an internal advocate for many years for us to be wary about how the fee structure influences our behavior, and while there is no doubt that your article, the other article I mentioned, multiple articles, audits, best practices put out by the OMB, the Section 800 panel report, all focus on this issue of the fees, whether it's by GSA or it's interagency contracting at the federal level. I will tell you that the focus, at least in my state, is less, there's awareness of the fees, but the real focus is there's enormous pressures from the agencies to meet these demanding problems in IT very quickly. And ours exploded when we had a massive data breach at the Central Department of Revenue, and the legislative mandate, the political pressure, get it done now and get it done quickly, was so enormous that it really catapulted how we behave. And I think that at least in my state, a lot of it, the squishiness in the definition is driven more by a lack of internal government staff that have IT expertise that can craft it well, and a demanding urgency to get it done now. When we bring someone like DOT or the Department of Education, we're the only state that buys school buses centrally, or at one time we were. The people at the Department of Education knew everything about every spec of every bus on the market. When DOT comes to us about asphalt emulsions or pretty much anything they buy, they have a massive amount, just an extraordinary expertise. On IT, we cannot compete with the IT vendors for the best qualified personnel. And so out the door, even writing the specifications, we're at a huge disadvantage, which pushes us towards those. And I'm not trying to be defensive. I'm trying to point out something that I think is a very real retort to what is a recurring challenge with these centralized IDIQ contracts, which is the fee structure. And it's a great point. I just wanted to provide a little fuller picture.
Yeah, I think that you really identified. So if you have an IDIQ with, let's say, an IDIQ for legal services, and all they define is lawyer, they just say lawyer X amount per hour, and they don't give specialty or years of experience, which is an optimal situation, arguably, from the centralized purchasing agency standpoint, because it reduces in transaction costs and makes your contract as worthwhile as possible. The challenge then is to make sure that the customer agency has the expertise necessary to be able to take that mushy lawyer contract at the master contract level and make sense of it at the task or literally order for precise. And the problem is precisely the one you just identified, which is that talent tends to migrate to the centralized purchasing agency or migrate to the private sector and doesn't reside then in the customer agency. And that's an issue really we should highlight in the model, and certainly in the commentary of the Model Procurement Code, that's an open question. If you were going to leave a lot of discretion at the purchasing agency level, such as having a no price master contract, if you're going to leave a lot of discretion at the purchasing agency level to sort out what the price is, you have to be sure that they have the capacity to do that. So I just want to close up this hour with a couple of questions that we got. The first one is, my perspective is that the qualified pool still needs to compete for the opportunity, and then getting on the qualified list is a separate process for competing for the actual opportunity. I think we're all agreed on this. That, yeah, it's the qualified pool ideally is the ones that are competing for the opportunity, but there's an intermediate step. The way that Scott, your approach is qualified list first, then those may be able to compete for an IDIQ contract, and then in turn we actually have the task and delivery order. Is that's your perspective?
It is, though, oftentimes there's no step one of qualified list, but yes, that's fine. On the IDIQs, I had two other quick points, if I may. One is, I think that it would be useful if the MPC defines the length of an IDIQ, the maximum length. In the federal system, we just assume 5 years, but there's no maximum length in the uniform guidance. But at some point, the competition that was underlying that IDIQ, assuming it was priced, is no longer really valid. And so there needs to be some sort of parameter. No one knows what to do. So just having a reasonable rule would be helpful. And then the second thing, by the way, if anyone cracks the code on IDIQs at the state level, grantees love the idea of what they call piggybacking, the idea that if they're allowed under state law to use those contracts, that they could then rely on the state's expertise in entering into the contracts to meet their obligations under the federal procurement standards. Right now, piggybacking is not really an option. It's extremely risky, and in most cases, not really an option because states don't have to follow the federal procurement standards. And so even if they let the grantees use their contracts, there's no guarantee, there's no way to validate that in fact the procurement process complied.
We'll talk more about that in the second hour, because I do have some to discuss there. I do want to discuss a little bit about the cooperative purchasing provisions in the existing code. So why don't we take a break until 10 past, and Yolanda will be joining us as well during the second hour. Thank you. Scott, can you hear me?
I can now.
Right, thanks. Sometimes I'm guessing other people's webinars and I say, wait a minute, you mean you don't have to do it all yourself? So it's incredible because I'm doing it all myself. And I thanks to the audience for your indulgence. So we're going to be joined now by Yolanda Williams. And Yolanda is a recent graduate of our LLM program. She's been a JAG in the U.S. Army for the past 13 years with 23 years of total military service. She's deployed to Afghanistan and served as a legal assistance attorney, trial defense counsel, administrative law attorney, and brigade judge advocate. She's licensed to practice law in New York and New Jersey, and she recently finished, as I said, the LLM program in government procurement law at George Washington University Law School. She's going to be heading to Fort Cavazos in Texas to be the brigade judge advocate for the 418th Contract Support Brigade. So thank you very much for joining us this evening, Yolanda. Let me just go to the different window here. So I'm going to go back, I'm going to put the slides back up. And as I said at the lead off, Yolanda wrote the paper. We had done a rough up of the gap analysis. Yolanda wrote the paper that elaborate on this gap analysis. In the next few days, we're going to be posting her paper as we finalize the changes, and it'll be a working document, a working resource for, among other things, for the students who'll be taking a course that we're launching in the fall on the reform of the Model Procurement Code. So the next section, by the way, with huge thanks to Keith McCook. Keith had to step away to deal with some family stuff. And so we're very, very grateful that he could join us for the first hour. So the MPC says that all cooperative purchasing conducted under the relevant article of the MPC shall be conducted through contracting awarded through full and open competition, including use of source selection methods as substantially equivalent to those specified in Article 3. So your reading of this, Scott, is that if you're using, let's say, the NASPO value point contracts, those master contracts have to be awarded using full and open competition. But you're reading this guidance to mean that that requirement for full and open competition doesn't necessarily carry over to the task or delivery orders. Is that right?
Correct. Now, as I say this is an area of ambiguity. The regulations don't specifically address the issue. So in my view, if you have a competitively sourced contract that was awarded through full and open competition, which the IDIQ is a contract, I mean, there's a minimum amount you have to pay under the IDIQ, then you are compliant. I could see agencies arguing this point, and the people who review these issues on the grants side of the system are not generally procurement attorneys. In fact, they're not generally attorneys, nor are they generally procurement people. They're agency reviewers with oftentimes backgrounds in the social policy areas that the grants are funding. So outside of Department of Transportation, for example, EPA maybe, you're not getting a lot of procurement expertise. So anyhow, that's a very long way to say, legally speaking, once you've awarded that contract, the IDIQ contract, as long as there's consideration, you should be good. But then there's just, it's not sufficiently, the way it's addressed isn't sufficiently clear to make me entirely comfortable, and it should be.
So Keith and an Italian procurement expert named John Luigi Albano, the three of us will be doing a panel in New Orleans at the NASPO Law Institute. And we're going to be addressing this question because, Scott, we also raised it with Dixon Robertson in the first session, which is, would it be simplest to start from the presumption that second stage, that the award, and I should be clear, that during the award of the orders, the task or delivery orders, that's really a contract. That would be the starting point to say it's a contract, and therefore, as a public contract, if it's above the simplified, let's say above some threshold, as a public contract, it should be subject to normal competition rules, normal transparency rules, normal socioeconomic rules, presumptively. And then you work backwards from that presumption. What do you think about that solution? It's elegant.
I'm not sure I fully follow you. See, if you're saying that the task order itself is, and I think the task order is a separate, in a sense, it's a contract in and of itself, but is that, I don't see how that answers this question, and I may just not be following the logic. Because
So-
the way I read this question is, am I already done with the competition requirement at the IDIQ stage, so now my task order doesn't need that? Is there another piece to this?
No, I think this is a starting point for your, what you called ambiguity, for your ambiguity. So one of the reasons to bring John Luigi in from your, and he's going to be joining us by video. One of the reasons to bring a European in is that the Europeans call that task or delivery order stage. They don't call it an order, they call it a contract. You have a framework agreement, which we would call the master agreement. And then the order is called a contract. It's called a framework contract. So we call it order, they call it contract. It shows that it's a jump ball. It's just a matter of different legal cultures calling it different things. And by calling it a contract, then you trigger all these public policy and legal concerns that surround a public contract. Transparency regarding opportunity award, et cetera.
You could, but then I think what you're saying is I think that would destroy the utility, the main utility of the IDIQ contract. So you could clarify that way, but I don't think anyone would use IDIQs anymore.
And I think that's because we, among other things, at a meta level, we have to figure out how the committee can work efficiently. And I think that what Dixon and I are kind of inching towards is start with the elegant abstraction and say, this is the elegant abstraction. This should be the rule in the ideal. The ideal rule, for example, would be task and delivery orders really are contracts, and we should treat them as public contracts, and they get surrounded with all the protections we normally afford contracts, and then back into the practicality, which is Scott saying, no, you're destroying the utility of the master contract. Agree with you completely. Start with the abstraction, then move back into the utility. Now, ironically, that's somewhat how the Europeans approach it. The Europeans start from very abstract principles, try to define rules from that, and then they compromise on the rules because of the practical and political necessities. So I hear you. I agree with you. The hard part is figuring out how we go into dealing with the practicalities without losing sight of the basic problem, which is this really looks to a layperson like a public contract.
But I think the compromise could be, and I understand that we're not going to resolve this today, but I think the compromise could be that in a single award IDIQ, so long as it's recompeted every, let's say, 5 years, the underlying competition that set the prices is sufficient to meet the competition requirement, and at least from a grant standpoint, the uniform guidance. Whereas a multiple award IDIQ, there's an expectation that the contract holders would compete for the task orders. And I think that might be a reasonable compromise based on that fundamental principle.
Okay. So driving those competition requirements that we see in the FAR into the task of delivery order.
For the multiple award IDIQs, yeah.
Yeah, we see that in FAR 16.5. Yeah. Okay, so this is the problem we're discussing, which is, do we deal with the second stage as a contract? And that's what we'll be discussing with John Luigi in New Orleans. We're discussing this question to see if we can come up with starting points and then dealing with the practicalities, including the ones you've identified, Scott. We'll talk a little bit about time and materials contracts. Yolanda, do you want to just talk a little bit about what you found with regards to time and materials contracts?
Absolutely. So obviously it is found here in the general procurement standards of the OMB guidance. It authorizes the use of the T&M type contract only after a determination has been made that no other contract is suitable, that the cost cap is in place that requires the contract to stay under a defined payment threshold. And if the contractor exceeds that defined amount, the contractor assumes the risk. So obviously there is some inherent risk with the T&M contract. So the rule goes on to warn against the potential to have open-ended price type contracts, since it's no incentive for the contractor to control the price with those types of contracts. And then it says that the non-federal entity is required to set a ceiling price that the contractor exceeds at their own risk. So that guidance is found in the OMB guidance. So the MPC, unfortunately, is silent on the T&M contract. However, the FAR permits TMN contracts under similar circumstances. And that is found particularly at FAR 16.601. So one of the things that I recommended in my paper is that the MPC should be updated to reflect model guidance on the TMN contracts, since they are contracts that's readily used in the federal government. There's already rules that kind of, determine how they should be used, and the guidance in the OMB kind of follows that guidance. And so that gives kind of some guidance to a state that is looking to implement this, some rules to kind of control contract costs and kind of to regulate these contracts that can have the potential to get out of control if you don't have guidelines kind of surrounding them. And then essentially this would permit the state and the municipality to have clear guidance and restrictions and insight on the pitfalls that you already kind of see, and you already have control mechanisms at the federal level. So that was kind of my guidance there for the TNM.
So Scott, in your private practice, are you a TNM contractor?
Yes, so everyone is, and that's actually a sort of a problem with this language in the uniform guidance. There's two problems with this language in the uniform guidance. The first thing is, if you talk to a typical grantee, so maybe not a state government, and I know our focus today is state governments, but even really at the local government level, if you say, well, how did you choose your contract type? They're not going to know what you're asking them. The contract type is a very inside baseball term. I don't know that it needs to be, but no one knows what that means, contract type. And you're supposed to document your rationale for your contract type as one of the other requirements in the uniform guidance. So that's thing one that's kind of a problem. But the TNM issue, so thing two that's a problem is, generally speaking, the buyers aren't choosing contract type. The pricing mechanisms that are coming in aren't in response to the solicitation. They're just in response to how the vendors, who are all commercial item type entities, price their contracts. And so TNM for any services, especially consultants, lawyers, accountants, it's all TNM. So this idea that you have to make a determination that the most suitable contract type is a time and materials contract. I have never actually seen that determination in a client's files, and I've never seen it become a compliance problem. I actually have advised, and to my knowledge, this has never become a problem. I advise our clients, my clients, to write into their policies if they're addressing this issue of having to determine that a time and materials contract is the most suitable contract type, if that's in their procurement policy. I always encourage them that the very next sentence should be, it will not be unusual given the types of services that we procure, the time and materials will be, in fact, the most suitable contract type. Because otherwise the procuring officials then within the grantee organization get very confused about whether they can do it. So there's a lot of problems with this language in my view. I think the uniform guidance should change here more so than the MPC adopting what the uniform guidance says.
Just in fairness to the rest of the world, asking a bunch of TNM contractors what's the best solution for TNM contracting may not be the best idea, but that said, move forward. So Scott, do you rip all your clients off? Do you just run big bills? Are there no constraints on what you do? Because that's
so there's a second. I mean, market is the constraint, right? Is are you worth the money? That's the constraint. If you're not worth the money, you're fired tomorrow. And so, I mean, all the lawyers in the room here know that we're all working very, very hard to not be fired tomorrow because there's a lot of competition. And so that's the real thing is the competition. And obviously with lawyers, there's the ethical rules, but if we're talking just generally TNM contractors, it's competition that really controls this. There's another similar restriction or requirement in the uniform guidance that's somewhat problematic, and that's the idea that if you don't have price competition, you're required to evaluate profit as a separate component of price. OMB has clarified in some guidance that that's only over $250,000, which mitigates the harm caused by that. But a lot of commercial vendors actually are not able to tell you what the cost of performance is, because their rates are just based, especially in the service industry, they're based on market. They're not based on cost of performance. Obviously, they'd go out of business if their rates weren't higher than cost of performance, but they don't even have the data readily available. So,
yeah, I think that they don't have so my personal experiences, they don't have the data readily available because in a fluid market, for instance, law firms look like they're highly structured, old-fashioned business and everything. That's not really true. They're extremely dynamic organisms with people, for example, going into new practice areas or some lawyers are working on one type of fee structure, and other lawyers are working. And if you try to figure out, okay, what's the cost basis for these lawyers? That can almost be dangerous if you try to. And so my over 30 years of private practice, I've seen cost analyses even within the same law firm rotate over time because people are applying different cost analysis. So trying to figure out what exactly is the cost of any given legal hour is very tough. So you said two very important things that are not in this thing, Scott. They're not in the guidance. One is the question of value, and the other is the question of market constraints. They go together. You said, if I'm not delivering value every day, I get fired. Okay. And there's nothing here that says to the contracting official, look for value. If you're not getting value, you've got a problem. Nobody's looking for that. They're looking for, are your prices too high? They're not looking for value, which is a different equation. You could charge $1 million, but if you're making $3 million for the client happily pays the $1 million. That's the reality of the marketplace. And you will get fired. You will get fired. And none of that's built in here. Yolanda, did you want to add something?
I think that's kind of what I was getting after too. I mean, obviously I came into the program with 0 to no experience, and I took both you gentlemen's classes just because I was fascinated by the subject matter. And it's just an area that you learn kind of about the T&M and the other aspects of the program, and then you see it here. And it does seem kind of vague, particularly for the interest that's put on it and other aspects of the program. So I think just defining those things for particularly states who have very unique and robust rules, just giving them some direction, even if it's just cleaning up the terminology and the language, it makes for a better ability to have them kind of align and moving forward and ensuring that everybody is kind of compliant with the guidance.
What you see on is kind of interesting is that on that point that you're just raising in terms of the practicalities of the implementation, if we look at FAR 12.207 on the T&M, what's interesting, we got a question about this in the Q&A about what about the not to exceed? Yeah, there's a requirement for not to exceed, but 12.207, the federal analog, the federal acquisition regulation analog to all this, it specifically contemplates modifying the contract to raise that cap. So you've got this ongoing situation where there is a nominal cap put on. Let's say the lawyers, you can't charge more than X amount, but they recognize that you can constantly raise that cap. It just becomes an administrative burden. Scott, do you see your clients going back and forth like that, where they will have a cap and they try to raise it, or they just ignore the requirement for a cap?
So they ignore the requirement for a cap. Now that said, and again, not an area that there seems to be a lot of compliance scrutiny. That said, I have never viewed the cap as something that would be overly burdensome to them. It would just be, I mean, there are a million things they're doing that are just administrative burdens that maybe don't serve the purpose that the government originally intended. And so it would just be another one of those, and it wouldn't be that hard, to administer. So it would be fine to put a cap. It would make them think about, well, how much am I really spending on this contract, which would be useful. But in that regard, I mean, I actually think the independent price estimate is a more useful tool than the cap. So to kind of take us back to that conversations.
So we got a question. Budget constraints and agency accountability metrics that tangible successful results are also constraints. I think the point I was making there is that this brings us full circle to the fact that if you have a T&M contractor that's not delivering value, then in fact the agency do grantees have the management flexibility, Scott, to fire their lawyer?
Yeah, I mean, yes. No, I wouldn't know. I've never been fired, but I'm sure they theoretically. No, yeah, there's no, I mean, the private nonprofits, they run, especially the larger ones, they're running like competitive businesses just without a distribution of profits. I mean, they're very sophisticated, many of them. But even the smaller ones, I mean, they're very flexible. They're running their business as a business. So.
And what I tell my students is I have been fired. And when I get fired, it more commonly has been because my price as a lawyer is exceeding the value delivered. And that is oftentimes because the marketplace is commoditizing around me. So for example, providing how to set up compliance systems advice was very tenable for lawyers, and it became less and less tenable over time because the lawyers' fees were here and the compliance professionals were here, and the lawyers could no longer compete effectively, and then the lawyers get fired because they're not delivering the value compared to what's available in the marketplace. Okay, we have a half hour left, and we have a lot of ground to cover in terms of contractor responsibility. If I could just throw in here just for a second, Yolanda, on what this slide and what the next slide mean, that the OECD published this year a very, very important, let's say call it a monograph. You see it there on the right-hand side. It's on taking risk into account in public procurement. And historically, what we've dealt with, really this program started in 1960. So the program is now over 60 years old. And the program and public procurement law in general has always focused on, okay, what are the mechanisms, the administrative law mechanisms for dealing with public procurement? Protests, claims, debarment. These are administrative law mechanisms used to guide the procurement process. And we've been doing that now for over 60 years. But in parallel is this whole world called supply chain management. And people doing private supply chain management, they don't talk about administrative mechanisms. They talk about risk. How do you contain supply chain risk? And what the genius of the OECD book, the monograph, is by bridging the two worlds and saying, look, in public procurement, what we're really trying to do is manage risk as well. And it's really, during the pandemic, we started talking about this because as we were dealing with our counterparts, with our professor counterparts in the supply chain world, in the pandemic, we clearly, public procurement functions were struggling with how we deal with supply chain issues. For instance, how does a CPO for a state get enough masks out there? But we really didn't completely bridge it. The OECD, what's really great about this monograph is it bridges between the two, and it says you can use this for compliance issues. We're going to see that. You can deal with sustainability issues like environmental sustainability, operational issues. You're using the same basic structure, which is you identify risks, you assess the risks, you treat the risks, then you monitor on an ongoing basis. And this is just a chart from the same OECD monograph pointing out how the cycle. You identify what the risks are, you assess what's the likelihood they occur, how severe will the impact be, do a risk evaluation and treatment, and you monitor on an ongoing basis. These are the rudiments of risk management, and they apply equally well to public procurement. And it has a profound impact, just as a collateral matter. For example, if the goal of a bid protest system is not to set up a mechanical way of dealing with angry vendors, but if the parallel goal is to mitigate risk and allow protesters to serve as a red flag or identifying when risks are emerging. And, oh my God, look, the agency isn't following the regulations, and that has this anti-competitive impact in the marketplace. If that's the purpose of protests, which is a red flag system for risk management, then the mechanical way we set up the protest system by giving standing only to the next best bidder doesn't make any sense. We should give everybody standing because anybody might have the insight to say, hey, there's been a breakdown in the system. So the administrative law structures, in many ways, sometimes they're hundreds of years old. These administrative law structures may not be the best for a risk management system. So this meshing together these two worlds of risk management and procurement, public procurement, can have a dramatic impact on how the law will unfold in the next few years. And it's really, something I'm going to spend the rest of my career talking about, this issue of how to bring the two together. And you can see it in things like the compliance structure that we use, the compliance structure that's been adopted all over the world, starting with the sentencing guidelines in the 1990s. It really is about standards and procedures as a way of identifying what are the material risks. The fact that in my standards and procedures, I'm going to make it illegal or not illegal, I'm going to make it improper, inappropriate for employees to smoke marijuana. You can say, you identify that as a risk. Some people may say that's not a risk. We're not going to put it in our standards of the standard of conduct. But some people may say, yeah, it is material. If they're flying airplanes, we're going to put it. So once you put it in there, you've identified the risk, and then everything else falls into the same matrix of risk identification, risk assessment, risk mitigation, and monitoring. It all falls, and that explains. I've been struggling now since since 2000, 2005. I've been trying to figure out why is it that compliance systems look the same all over the world. The answer is they're all doing the same thing, which is they're doing risk mitigation. If you ask a risk mitigation person, a supply chain person, to put together a legal structure that mitigates legal risk, they would put together these compliance systems. That's why the compliance systems all look the same, because they're dealing with the same problem, really in the same way. It's a clever, supple way of dealing with risks. So in that light, where we're dealing with risk mitigation, then we come back to the standards, the standards from OMB, and the standards said the non-federal entity must only deal with can only award contracts to responsible contractors, and consideration will be given to such matters as contractor integrity, compliance with public policy, etc. So the practical problem is, and Yolanda, this is a hard question for you. I'm going to throw this at you. In some ways, I'm cheating here, Yolanda, because this is stuff that I've been working on. While you've been training at the Army, I've been goofing around with these slides. So the problem is, if you look at the MPC on responsibility, it doesn't really talk about what responsibility is. It only talks about what non-responsibility is, okay? It sort of presumptively assumes that everybody's going to be responsible and says you make a finding, this is how you make a finding of non-responsibility. Do you think we need to update the MPC, Yolanda, so it talks more about what the affirmative standards for responsibility are, as opposed to just talking about non-responsibility?
Absolutely. And I think that also kind of aligns with the risk assessment that can be done prior to finding yourself in one of these positions that had you done a little bit of forward thinking in the beginning, you wouldn't have probably even entered into a contract with that contractor. I mean, I think I spent the year kind of learning about when it goes bad, right? You learn about when it's good and what the rules should look like, but then you study when it goes bad. And if you're really looking to kind of educate, personnel that don't really have maybe the experience, they never had to think about these principles that are readily available and commonly understood at the federal level, then there should be some definition surrounding what right looks like, right? And forcing mechanisms to make you think, the reevaluation stages. I mean, the risk analysis for me, being in the military, is what we do every day. These principles aren't new to me, like leadership, basic principles of leadership, management of soldiers, just what we do every day kind of goes into that risk continuum that you spoke about. I mean, the intent for that is to make sure that you're capturing things that are red herrings that are obviously out there that you can avoid. So I think the same should be true kind of for contractors. We shouldn't talk about what goes wrong. We should also identify for personnel what is right? What right looks like. If it is unknown, where you can go and find the answers, what has worked before. But I think, and you and I have kind of discussed this in class, I think sometimes we can be too restrictive because you want to be able to permit people to be innovative and look for ways to do things that we've not done before. But obvious things like fraud or incapacity or, basic things that that they're incapable of doing because there's a proven record, you should have the responsibility of going out to look for it. I don't know if that answers the question, but that's just kind of an opinion from someone, that doesn't have a whole lot of experience in the area, just kind of thinking, for a way forward.
Yeah, and so everybody knows what we're talking about, Yolanda. You can look at what we're talking about here is the standards for responsibility in the FAR, which are affirmative standards. They say these are the things you should be looking for, whether or not they have adequate financial resources, et cetera. What's ironic, Yolanda, is it's buried in the commentary. The commentary to the MPC, the old MPC, the 2000 MPC, it says this is what makes a contractor responsible, but it's really, those standards really aren't in the statute themselves. They're just referred to in the commentary. What is it affirmatively that makes a contractor responsible? And the reason that's important is if you lay out, okay, these are the issues you'd be thinking about, then logically other governments can start using that same information. When we assess professors, what are the things that we're going to assess? The professors have glasses. That's part of the responsibility. The professors have a necktie. They have a shirt of a certain color. These are the things, these are the elements so that other students in other schools can assess the professors at GW because they're using the same elements of responsibility. That's the idea, to have a structured approach as opposed to a going code, we're only going to talk about non-responsibility. We're not going to really lay it out. You have that transfer of information. And then, Yolanda, then we hit the next problem here, which is the right of non-disclosure. If you look at paragraph 2, it's presumed that the information will not be shared outside the government. And that's really scary, because where we're going right now is we have all these sources of responsibility information that are available from around the world. They're available from other governments in our own country, and we should be able to draw on those because, as you put it, the goal is try to reduce risk. And if you can draw on that structured information from other places, like, oh, red flag, this contractor has done these bad things in this other state, then that is very, very useful for responsibility determination. Scott, did you have a comment?
I did, and it relates a little bit, I think, to one of the questions. I had 2 comments, but one relates to one of the questions. But I had always construed responsibility as a very simple definition, and I think this may come from GAO, which is essentially the capacity, and I think the way they described it is the will to perform, but again, I think it means business integrity necessary to perform. And in my view, as far as definitions go, that's a simpler definition that's less likely to be second guessed. And if I was the buyer carrying out the procurement, I'd be very concerned if it was federally funded, that my responsibility determination would be second guessed by the funding agency if I had too many factors that I had to check off. So that was thing one. The question that came in, and I think we could possibly come back to it because I want to make one other point, was how far do we go with the definition of what responsible means? Does it mean to perform the contract, or does it mean as a citizen of the world, right? Child labor, things of that nature. But the other comment I had is I do think there's a separate inconsistency in the broader system that needs to be resolved. And that is the non-procurement suspension and debarment rule tells me explicitly that even though someone's been determined to be non-responsible through the non-procurement suspension and debarment process or the procurement suspension and debarment process, I can look them up. They're on the excluded parties list system. Under that rule, which is really the primary rule in this area, I'm still allowed to contract them as long as my contract's under $25,000. And that to me just is a very unusual inconsistency. I will say I tend to advise grantees that because of the rule in the procurement standards, if someone's debarred or suspended, don't try to rely on that $25,000 exception in the non-procurement suspension and debarment rule, but it needs to be addressed. It's a significant inconsistency.
Well, but I think you've answered your own question. The threshold question you have, or the question we have here in the Q&A as well, how far will this go? I think you're concerned about grantees using this $25,000 exception, Scott, because you're concerned that reputational muck will stick to them if somebody's been debarred. That even if there's a small contract, because remember the performance risk is low, below 25K, so it must be something else. It must be reputational. Well,
and I should clarify, I mean, I live in constant fear, or my clients live in constant fear of a disallowance. So it's not so much that the contractor won't perform, it's that if it turns out they were excluded, the federal agency reviews a couple of their contracts, types the names into SAM, and if they're excluded, it doesn't matter if it's a $5,000 contract, there's a high likelihood that cost would be disallowed, and they'll have to pay it back, even though they have to pay the vendor still. So
in this question, this goes back to the question of the exchange of information. The debarment list is only a list. It doesn't tell you why. And if you're making an assessment based on performance risk and probably reputational risk, if that's really what a responsibility determination is, and it really also underlies the debarment decision, logically the why, the basis for these decisions for debarment, just like the basis for responsibility, those should be made available at least to other government agencies, because they may have a different view, Scott, on the risk. They may view, this agency does not willing to deal with bandits. Because they don't want the reputational risk. But some agencies, like in a war zone, they may be willing to deal with bandits. They may be willing to take on the reputational risk because they really need to have the bandits on their side. Does that make sense? I think it also answers the question you raised regarding being second guessed. If one agrees that these are reputational and performance risks that somebody has to assess, who should assess? The customer agency should assess it. They need to have access to as much information as possible to do it. But at the end of the day, they shouldn't be second guessed as long as they're making a reasonable effort to understand what information is available, to identify and assimilate the information that's available regarding those two key risks, the reputational risk and the performance risk. The question here of where we draw the line, I think that the practical answer to the question is, since most of these issues are fought out through a bid protest, it's more a matter, has the agency made a reasonable effort to find and process the information that is relevant information. And so we don't have to draw a line in the abstract, as long as in good administrative law practice, the agency has made a reasonable effort to assess the information that's reasonably available. Okay, it brings us back to this, that if this is a risk analysis, have they done a reasonable job in making the risk analysis? Have I dodged the bullet here, Scott? Because
I think so.
yeah, because that way we don't.
I think the reality in the grant system, or I shouldn't say I think, I mean, the reality in the grant system is that it's not the bid protest you're worried about. It's the federal agency that looks at the procurement 3 years later. But I think your points are all well taken.
Well, but I think, this is one of the reasons I'm going to beg you to stay involved in this process, Scott, because you really know the mechanics of the grants process. If the grants world is really different, where we're not really dealing with what's the risk, that the performance risk or the reputational risk that's confronting the customer agency, but instead we're dealing with how to survive an audit from 3 years from now, do the rules have to be more mechanical?
Yeah, and it's interesting you say that, because I think if we look back all the way to sort of the beginning of our discussion today, I think I've sort of often taken the position of we either need to be clear that there's discretion or that the rules need to be more mechanical. And probably what's driving my perspective is that I view the entire world through, well, 3 years from now, someone's going to look at it and I have to show them I check the boxes.
That's a salient point, that we do want to create clear rules, clear safe harbors. And the attendee said exactly, it really is agreeing on that. Okay. Okay. And here the logical corollary, Yolanda, to having a responsibility determination where you're really trying to assess, among other things, the contractor's integrity, is by requiring that the contractor undertake compliance obligations. And then the research question for us, Yolanda, as we're going forward through this process is, okay, what kind of compliance obligations do we see in the states? Because they're not right now. The compliance structure that we see under FAR 52203-13 isn't universal. It's new at the state and local level often. Scott, when you try to persuade your clients to set up compliance structures, to set up compliance systems that look like this or look like the one we showed before for the international standards, what's the response?
Well, when it comes to managing contractors, I can't say that in detail I've ever worked with a client to set up a compliance system for contractor performance. Some of the larger, more institutional entities I'm sure have it. I've never worked on it. But the thing that from my perspective always drives that relationship is, first, if they're talking to me, it's because they're worried about the federal procurement standards. Those are very heavily focused on contract formation. But there is a requirement that you have to manage the contract. But that tends to boil down to, did I receive the deliverable? Have I verified that I received the deliverable? And the thing that I paid for, I got the value that I bargained for. And this is much more detailed than that basic analysis. Compliance systems in the grant system tend to be driven more in terms of, am I complying with all the stuff that's in the uniform guidance? And there are some very specific things you can do. But in managing the contracts, I can't say that I've ever seen down into the weeds of that. It's just never come up.
So
Maybe it's terrifying to you, but
no, it's and by the way, from the time I started as a professor, I was pushing hard for that the sentencing guidelines compliance requirements that really came together in the mid-90s and had by the late 90s had been adopted by corporate America in general, because it created an affirmative defense or created an argument against heavy sentencing and in the district courts if you had a compliance system in place under the sentencing guidelines. So corporations had an incentive to have a compliance system in place, and the major defense contractors, if you trace back the history, they had them in place since the 1960s. Ironically, a lot of the mid-1990s standards and guidance on compliance systems actually came out of the defense industry, and then Secretary Cheney decided not to apply them to contractors. Instead, for 10 years, the contractors had the Defense Industry Initiative, an independent initiative to self-police, and it wasn't until 2008 that we got this. We got 52203-13. So basically UCANS was engaged in 6 years of whining, and my job, ironically, as a professor, was that members of industry who agreed with me couldn't say so publicly, but they kind of nudged UCANS along to be the whiner. That was my job. What was funny at the end was the fraud task force inside the government took this and added a mandatory disclosure obligation. And so, to my complete surprise, I was stunned. Somebody from the task force left me a voicemail on my law school voice, and I came back to listen to it after Christmas vacation. He said, "Thank you, Professor. We wouldn't have had a mandatory disclosure obligation if it hadn't been for you." That wasn't my idea. My idea was to have compliance, but the logical complement to a compliance system that calls for cooperation is arguably the next step, which is a mandatory disclosure obligation. So here's the $64,000 question for you, Scott. To whom should the grantee be making that mandatory disclosure? In the contracting world, it's pretty clear: contracting officer and OIG. Who would be the analogs? When we get to this point in our discussions, who are the analogs in the MPC world? Excuse me, in the grant world to a inspector general and a contracting officer?
So, so the short answer to that question is the grants officer and the OIG. So it's essentially the same function. In some agencies, that grants officer is a contracting officer. So DoD uses contracting officers as grants officers. I think USAID does the same. In a lot of the civilian agencies, they're different people. I do want to say that there are requirements for maintaining. In fact, whenever anything that goes wrong, one of the sort of tack-on charges is you failed to maintain adequate internal controls, and there is a standard for internal controls that's applied to grantees, and it's the GAO Green Book standard, and where you find it in the uniform guidance is at 2 CFR 200-302. There is also, by the way, a mandatory disclosure requirement for grantees that is based, I believe, on the FAR standard. It's very similar, but it's not exactly the same. So at 2 CFR 200.113, there is a mandatory disclosure requirement, but it's for, I'm doing this from memory, but it's for criminal violations involving fraud, bribery, or gratuities. Federal criminal violations involving fraud, bribery, or gratuities that have the potential to impact the federal award. And they have to be timely disclosed. It doesn't include, like, the FAR standard Civil False Claims Act violations, much to my pleasure, because no one knows what a Civil False Claims Act violation is, or if you do, you think it's everything. And so that's a really, really tricky mandatory disclosure standard. I guess it's it's a full employment opportunity for lawyers, but it's a very difficult standard for mandatory disclosure. So the grant system is similar, it just doesn't have the Civil False Claims Act piece.
That's very interesting. Yeah, what happened during this rule set was kind of unique because it went through a bunch of different iterations. And the first set said criminal fraud. You have to mandatory disclosure for criminal fraud. And I went and talked to the criminal fraud guys, and I said, when the civil fraud guys see this, they're going to want to include civil fraud as part of the mandatory disclosure. I said, nah, that'll never happen. Well, sure enough, when the final rule came out, it said civil fraud to be included as well. So that the civil fraud unit within Justice climbed aboard the bandwagon and said, no, we want to make this a mandatory disclosure as well. The criminal fraud folks were very clear that the reason that they made criminal fraud a subject to mandatory disclosure is because of what lawyers would call deal flow. There weren't enough cases coming in through the voluntary disclosure program on the criminal fraud. They wanted to have more cases. They thought there was more fraud out there that wasn't being unearthed. And so they wanted to make it the subject of mandatory disclosure. And then the civil fraud folks followed as well.
My perspective, and this is a very biased perspective, my perspective is one of the challenges with mandatory disclosures is that the agency response to the disclosure is always heavy-handed. And so you'll be told by the agency is, look, thanks for letting us know about this. It means we're only going to double the damages instead of treble them. And that's not, I think, ultimately what the agencies are really seeking to get through the consultation process, but it is, in my view, how they're generally reacting. And so that for the system to really fully work, I think there needs to be a little bit more consideration on the part of the agencies of how aggressively they're responding to the disclosures.
The alternative, just to put it out there, the alternative is the World Bank's voluntary disclosure program. But the World Bank's voluntary disclosure program is like the Little Prince when the snake swallows the elephant. You make a voluntary disclosure to the World Bank, and the World Bank swallows the elephant. For a couple of years, nobody else knows what's going on, even if the bad acts that are at issue can involve other governments. There isn't any requirement for the World Bank to transfer that information to governments, and so government it's a isolation of the problem in ways that may not be healthy for the system overall. Okay, just want to talk quickly about organizational conflicts of interest. So the MPC doesn't say anything about organizational conflicts of interest. Do you think, Yolanda, that the MPC could be brought up to speed with what the OMB guidance requires regarding organizational conflicts of interest?
Absolutely. I think that this might have been one of the areas that I had a very long and deliberate discussion about, just because in my studies and kind of through the program, this is the area, particularly in the States, where you'll have those underlying very personal relationships, especially in the smaller communities where they might have always done business as usual, but that may not always lead to the best or most efficient, costly, or economically any measure for the organization. So having some rules in place that kind of requires them to understand what an OCI looks like, what an organizational conflict of interest is, and not necessarily, that doesn't mean that the organization that is involved in the analysis is automatically going to be cast aside, but at least making them kind of think through the process of when it is best to kind of make that decision for the state or the local government and kind of engaging with those particular businesses.
Yolanda, you've really raised something important here, because this definition of OCIs covers things like a contractor writing a spec against which an affiliate will be bidding. It covers a situation where a contractor may pull her punches as a consultant, may not provide really in-depth information to the customer agency because an affiliate could be affected as well. It does, but Yolanda, you raised the third kind. If you look at like the Minnesota, which really adopted the federal structure, there's a third, which is unfair advantage. You've identified, you said, look, some situations you could really have a good old boy situation where they're, because of a repeat player or whatever it is, they may have an unfair competitive advantage. And OCI rules need to be able to address that. But the guidance from OMB doesn't cover the old boy situation. The fact that somebody may have an unfair competitive advantage. So do you think that in implementing this requirement, we should take cognizance of the federal example, from Minnesota? I don't have South Carolina here, I should, but should we also include something regarding unfair competitive advantage?
Absolutely. I think that was, I can't recall everything from the paper, but that was one of the things that I had particular interest in, is because you do have, I've worked in local government before, my time as a law enforcement officer, when you're in these small, very intimate relationships, I don't think that sometimes it is even the intent to do anything inappropriate as much as it's the way that we've always done it. But if it doesn't best serve the, the state or the local government, then we should look at ways to re-engage for several reasons. Maybe the contractor figures out better ways to be more cost effective to provide the service, because maybe they are the best, person to provide that service, but it puts the onus on the personnel to kind of look without those boundaries. And then that supports some of the other, I think I spoke to this in my paper, that gives them the opportunity to support some other kind of avenues. Maybe there's a small business that can provide the same service more economically, or a minority or veteran owned, all those other policies that's kind of out there that many states, I get the impression, aren't required to look at because nobody's ever told them that kind of is a thing. So I think that definitely if you're going to address it, then you put at least that paragraph in there, not to automatically do away with all the business relationships that's been formed, but to give them a different perspective to kind of make the best decision for the state or the procurement agency that's looking to do the contract or perform under the grant.
So and when we were dealing with this in the UN model procurement law, the item 1 and item 2, it's funny because the American delegation said clearly item 1 and item 2 we want to deal with as organizational conflicts, and they showed up in the UN model procurement law. We said item 3 is kind of a mess. It's kind of vestigial in our OCI rules that date back to the 1960s, and it's really hard to enforce because GAO really doesn't like this rule because almost everybody has an unfair competitive advantage. That's what makes somebody a successful competitor. The difference between comparative advantage and unfair comparative advantage is really hard to discern. GAO has really been reluctant to enforce this item 3. And we said, we're not sure we want item 3 because it's so hard to use. And the other nations, really interesting one, they said exactly what you said, which is the antitrust rules, the normal competition rules aren't necessarily enough to remedy these subtle questions in a given jurisdiction where we should really be thinking about competitive alternatives. Having this dangling thing out there where you may have an unfair competitive advantage, therefore you may be disqualified. Having this dangling thing is a prod to make the system work better. And so ultimately it wasn't the US delegation, it was the other delegations said, no, we want to keep item 3 as well. Yeah, and this is the attendee says there's no way to remove the judgment entirely. The procurement professionals have to judge the issue of unfair advantage. I think you're right. It's a matter of, ultimately it's going to be a matter of discretion. I've gone over time here. Scott, did you have a last word?
Not at all. I didn't realize the time. We're good. Thank you.
We're good. So, and as I said before, we're going to be meeting at 6 o'clock on Thursday, 6 o'clock Eastern. We'll be talking about cybersecurity issues. Brandon and Jacob are going to be talking about what they discovered in terms of what the state and local governments have done in cybersecurity. And then we'll be talking about state ramp. So please join us on Thursday. Thank you both for joining us this evening. And again, have a good night. Take care. Bye-bye.
Thank you, you too. Thank you for having me.
Yeah, bye-bye.